to our friends and viewers around the world. My name is Yinka Dansalami, and welcome to another episode of Know Your Rights on NABNTV, a program that provides you with general information about some of your constitutional rights in the United States. The U.S. Constitution provides certain rights to all residents in the United States, whether we are talking about immigration, landlord, tenants, housing, employment, or if you are charged with a crime. Today, we will continue with our discussion on immigration, particularly deportation. We will also answer some of your questions you sent to us from our previous show. We have in our studio today Esere Onaduan, an immigration criminal law attorney. She will help us to break down the concept of deportation. Also in our show is Carla Prosper, another expert who has agreed to appear to join us today, despite her very busy schedule, to answer some of your questions from our previous show. Welcome, ladies.
Thank you.
Esere, I know you've been practicing in the area of immigration and criminal law for some time now. Can you please tell us a little bit about yourself?
Yes. My name is Esere Onaduan. I am a criminal defense attorney in the states of New Jersey and New York. I do federal criminal crimes, state criminal crimes in both states. I've been practicing for almost 15 years now, and my practice includes anywhere from felonies in misdemeanors, municipal court issues, as well as removal cases, which means deportation. That's when the United States government is trying to remove somebody from the United States and deport them back to their country.
You have your own law firm, is that correct?
Yes, my law firm is called the Law Offices of Onaduan and Delence. Our office is at 116 West 23rd Street, the 5th floor, New York, New York. But we do practice in New York and New Jersey. That's excellent.
Do you also practice you say you practice in the federal court as well, right?
That's correct.
What does that mean?
I've been appointed as what they call the CJA panel, which is the Criminal Justice Act panel. That is where the federal government will pay attorneys like myself to represent people charged with serious federal crimes that cannot afford to hire their own attorneys.
Thank you very much. Carla, I know you were here the last time. Can you still tell us a little bit about yourself?
Well, thank you again for having me. So my name is Carla Prosper. I'm an immigration law practitioner. I've been practicing for approximately 14 years now. My office is in Clifton, New Jersey, but I take cases on throughout the nation. I'm licensed to practice in New York and New Jersey, and I primarily only focus really on immigration and nationality law.
Thank you very much, Carla.
Thank you.
Esere, I know all our viewers, when they hear the word deportation, they go crazy. They don't know what to do. Can you tell us a little bit about deportation, the concept itself? What does it mean? How does one get deported? Can you please, enlighten us about this concept, about this idea of deportation?
Absolutely. I'd be happy to. Deportation is a word that is used quite often. And sometimes another word for that is called removal. So what happens with deportation is the United States government will find someone who has either overstayed their visa here or has done something in the country that makes them ineligible to continue to stay in the country. So when that happens, you receive a piece of paper called a notice to appear, or you might hear it called an NTA for short. And on that piece of paper, it will list all of the reasons why the United States government believes that you should be removed from the country. So it's not that you just get the paper and they pick you up and they put you on a plane and then you're gone. What has to happen is once you're served with that paper, remember called the NTA, you are ordered to appear in immigration court so that you can address the issues that the United States government are saying are the basis for removing you from the country.
What if you don't get that paper?
If you don't get an NTA, that doesn't mean that you're not deportable. It also doesn't mean that one doesn't exist. There could be an NTA out there that exists for you, but you just have not been served. The thing to remember is that if you have not been served with an NTA or the notice to appear, remember that is the name of the document, then you do have some grounds to challenge your impending deportation or removal. But the proceedings can still be started in court just because you didn't receive the paper.
Can you address, you say, there are various ways by which one can get deported. One is overstay and one is ineligibility. Can you please tell us about, certain things that someone can do to make that person deported without the unlawful presence?
Yes. One of the issues that has been coming up lately is deportation based on criminal convictions. So there are certain crimes in New York, New Jersey, all over the country that makes someone deportable, what we call deportable. And what happens is if you are arrested for something, sometimes you are held in jail pending the outcome of your criminal case. If that happens, that is one of the classic ways that I've seen that someone can enter deportation proceedings. The reason that happens is because in the criminal case, if you're being held pending the outcome of that criminal case, sometimes what we call ICE, which ICE is Immigration and Customs Enforcement, ICE will issue what's called a hold. It is a piece of paper that they send to the criminal jurisdiction to say, do not release this person because we want them for immigration purposes. When that happens, ICE will serve you with the NTA, the paper we talked about before, if your criminal conviction makes you eligible for deportation. So not every criminal conviction, but there are some that have been isolated in New York and New Jersey that make someone eligible for deportation.
What are those types?
Some of them just very broadly, the one big one that we always say in practice is an aggravated felony. And there are, depending on what state you're in, aggravated felonies can be defined differently. It's based on the way the state actually defines the crime.
So what if a state defines a crime as a misdemeanor? Can the federal government define it as aggravated felony?
Yes, that often happens, unfortunately. And the guidelines in the INA, they escape me particularly now, will have to determine whether or not the language of the law in that state, even if the state labels it a misdemeanor, if the language and the words that are used are the same as the language and the words that the federal government used to define aggravated felony, then it will qualify as an aggravated felony.
Carla, you have the same experience in your practice?
Yes, and this would happen where a misdemeanor in a state for drugs or maybe child abuse is considered an aggravated felony. For example, maybe in a state, a child abuse conviction is a misdemeanor. When that charge is brought to immigration, it will be considered an aggravated felony. And this is also for drugs. I've seen that a lot in practice.
Okay. So now let me address the issue of a conviction based on moral turpitude. What does that mean?
A crime involving moral turpitude, that is the most, in my opinion, I think it's the most vaguely defined term in criminal and immigration practice. And so what I like to inform my clients is that we have to look at the basis of the crime. So in New York and New Jersey, most of these crimes have been identified as theft, petty larceny, anything dealing with deceit or fraud or any falsification of something. That is generally what we see as crimes involving moral turpitude.
Let's say that I jumped the turnstile and I didn't pay for my fare and I got caught. Would that be considered as a crime of moral turpitude?
In New York State, that crime is called theft of services. And colloquially, we call it a fare beat. And if you plead guilty or are convicted of that, it could be a crime involving moral turpitude, even though it's only a misdemeanor. And if you are arrested and convicted, you're probably never going to do jail time. You probably will pay a fine. But the fact that the theft is an element of that crime, it is a crime involving moral turpitude.
A good guideline for crimes of moral turpitude is the intent. So if theft, there's an intent to deprive somebody.
You mean the element of the crime? The
element of the crime. When it has an intent to hurt someone, to deprive somebody of property, it will most likely be deemed a crime of moral turpitude.
Is there a monetary value limit as to, as to that crime? In other words, let's say that, I forge somebody's bank check and I withdraw like maybe $10,000, from this person's account. Would that be a crime of moral turpitude?
Yes. Now, I want to be very clear. There are crimes of moral turpitude and there are what is called aggravated felonies. I like to call aggravated felonies the kiss of death, because if you've been convicted of an aggravated felony, your options for relief are very, very limited. So a crime of moral turpitude, as I previously said, involves some element of intent. So no matter how bad the fraud was, it will be the amount of the fraud, it will be considered a crime of moral turpitude. Now, not necessarily an aggravated felony, which is a lot more serious. For an aggravated felony, as SRA previously stated, it's codified. It's in the law. So for a fraud, it would have to be an amount of more than $10,000.
Okay. So there is a difference between fraud and aggravated felony.
There's a difference between crimes of moral turpitude and aggravated felonies. Yes.
So what are the defenses? Does that mean that, there are certain defenses that, you may mount, for someone, who has been convicted of either fraudulent crime or the crime of or something that involves aggravated felony? Absolutely.
So, and SRA and I, we always speak about this. The moment you are charged with a crime, it is important to have not only a criminal defense attorney, but an immigration attorney, if you are not a U.S. citizen, who can work with your criminal defense attorney to find the best option for you. Go ahead. No.
That's really important. I can't stress that enough, because sometimes when my clients get arrested, they come and find me. Of course, I'm an immigration lawyer as well. But when you're dealing with someone who only does criminal work, even if the case is not ending, you're not taking a plea. Sometimes we do things where the prosecutors will want to sit down with our clients to kind of negotiate a plea. Some of the things that you say in that negotiation, you can admit to certain behavior that immigration could interpret as crimes involving moral turpitude, even if you're not convicted. It's always best to have an immigration attorney on hand as soon as you get arrested, because your immigration attorney can not only advise you, but advise your criminal defense lawyer, so that when you go in to do what we call either a proffer or an interview or a conversation with the prosecutor to try to mitigate your circumstances, you're not saying things that are going to negatively affect your chances of getting immigration relief. Right, Carla?
That's correct.
Can you please elaborate on that? In other words, if I hear you correctly, you appear to be telling our viewers that even if you are not convicted of a crime, but because of the profile or, what you are admitting to, immigration may still use that against you. Is that what you're saying?
That is what I'm saying.
Immigration is, it's not a right. When you're before an immigration officer or a judge, you're asking for the privilege, for lack of a better word, to be a U.S. citizen or a resident. And therefore, the judge or the officer can look at records beyond your conviction. They could ask for the criminal complaint. They could ask for the plea agreement. They could ask for notes. And this will affect your case. It can affect your case. So it's very important. I don't know how many times we should say this. The moment, if you are not a U.S. citizen, this includes residents, because people believe that permanent residents.
I was going to ask you that.
No, this includes residents.
They can be deported.
The moment you are charged, you contact your criminal defense attorney, or you get a criminal defense attorney, and you get a immigration attorney.
So in other words, whether you have your green card for 50 years, as long as you are not a U.S. citizen, you are subject to deportation. Is that what I'm hearing?
Yes.
Yes, that's correct.
We've had tragic cases, where, a child comes to the United States, 3 years old, the family was negligent, and he never naturalized, got caught up in the system, and is now being removed to a country they've never been to. I mean, you know what I mean? Like a country they know nothing about. So this is real. This is legit. Like, get naturalized, things happen. And if you're not a resident, you're always in risk. I'm not trying to scare anybody, but you're always in risk of being removed.
I mean, what Carla is saying is true. I did an individual hearing, which would be, I guess, an immigration trial with a resident. He had a green card, and he had been served with an NTA. Of course, he had a very long criminal history, but they were trying to deport him. And he didn't know that he could be subject to deportation because he was not a citizen. He thought just having his green card and being a resident for years in this country would protect him. That's not an absolute protection. So
now you are now served with NTA, and you now appear before immigration judge. So what are some of your rights or some of the defenses that you can mount? Whether maybe if the NTA is based on criminal conviction or the NTA is based on unlawful presence. What are some of the defenses that you can mount?
Firstly, in immigration, unlike criminal defense practice, you do not have the right to an attorney. The government will not give you an attorney. So you'll have to get private counsel. When you're placed in removal proceedings, as SRA referenced, you will be given a notice to appear. And usually at the first hearing, the judge will want to go through all of the charges, all of the reasons why you are not authorized to stay in the United States. The reason they try to do that in the first hearing is because they want to establish that they have jurisdiction, power over your case to determine whether you stay or not. Right? Because if you are a U.S. citizen, they can't touch you. You stay here, right? If one of the charges are wrong, you're not removable. So that has to be addressed first. But if you go to court pro se, it may seem like a simple document. Always request for time, because removal isn't automatic. You have an opportunity. There's due process. You get to go to court and present your case to try to defend yourself to stay here. You don't get the letter and you're doomed. You don't have to buy your ticket immediately. So.
I know that sometimes when you do appear in court on an NTA for the first time, just like Carla said, the judge goes through all of the charges. The benefit of having a lawyer there, and this I'm speaking from personal experiences, I had a client who had a very long criminal history. That's what I do. And one of his charges, his conviction was for drug sale. However, we were within 45 days to appeal the criminal conviction. So part of the defense was this conviction is not permanent because we're filing an appeal. So it's the small things like that that will buy you some time or give you some defense, something to say in that moment that you can't see with the naked eye.
So in her case, if her client had appeared pro se, he would have admitted that he had a conviction.
Yes.
But there was no conviction yet because it wasn't final. So these are the nuances.
We would like to take this opportunity to appeal to you to advertise your product and be one of our sponsors, so that we can continue to disseminate important information about the rights that you have under United States Constitution and other federal and state law. Welcome back. Esri or Carla, either one of you, can you please tell us, how does a permanent resident get deported?
Sure. The three most common ways that I've seen are when a permanent resident has two convictions for CIMTs, what we call crimes involving moral turpitude, an aggravated felony conviction, which we talked about previously. And the biggest area is drugs, any type of drugs. And I think one of the most common misconceptions is that as long as the drug is marijuana, you're not deportable. And that's not true. The only thing that you can get a waiver for is if it is possession of marijuana less than 30 grams. And another big issue is the idea of drug trafficking, right? What does that mean? And some clients I've come across believe that if they did not receive money for giving someone drugs, then it's not a drug sale or what immigration will call drug trafficking. The exchange itself without money will be classified as trafficking drugs.
And I just want to piggyback on what SRA said about marijuana. We're living in very ambiguous times in the sense that many states have legalized marijuana for either health or recreation uses, but federally for immigration, it's still considered an illegal offense. So it's a very gray area where there isn't an immigration statute that says, oh, because in Colorado it's legal, you're okay. And the same for prostitution, because prostitution is legal in Las Vegas, but federally for immigration, it's still a deportable or inadmissible offense. So that's just one thing I wanted to point out.
I see. All right. So, if will a permanent resident will I also be served with this NTA that you mentioned previously?
Yes, because that's the
engine. It's like the engine.
Yes. So okay. It's in what I call a charging instrument. So if let's just say if you're just arrested on the street by NYPD, they have to give you a complaint, something saying what you did wrong, right? So the NTA is the same thing. It's like the complaint for immigration to get the process started.
Does the time that I have been in this country, would that affect or would that be counted, or how will it work? Will it affect, my position with the immigration in terms of whether they can remove me or not?
Yes. So with immigration, certain waivers depend on the amount of time you've been in the United States, the amount of time you've been in the United States without any convictions. For example, SRA described 3 scenarios where a resident could be placed in removal proceedings, the 2 crimes of moral turpitude, an aggravated felony, or marijuana possessions. For the crime of moral turpitude, there would be a waiver, but that waiver does require that you had been in the United States for a certain amount of time without clear of convictions. The aggravated felony, unfortunately, there are no waivers, so it doesn't matter how long you've been in the United States. That's why it's such a power. That's why I always say it's the kiss of death. They do not look to the length of your stay in the U.S. for the aggravated felony. Now, the law did change in 97. So if you did plead guilty to what we call aggravated felony is a term of law, which was codified after 97. So depending on your conviction, there may be a waiver. If it's in New Jersey, it's September 1st, 96. In other jurisdictions, it's April 1st, 97. So that could be a saving grace. But aggravated felonies, generally, there's no waiver. So it doesn't matter how long you've been here.
So it's better to be a citizen before you get caught in all this stuff. Is that what you're saying?
Yes.
And just one piece of advice that I often give clients: if you are a permanent resident, or let's just say even if you are just on a visa, if once you marry a U.S. citizen, there is no need to wait before you file whatever paperwork is necessary to adjust your status. I know people, or I've had clients who've been married for years and 3 children, and they never filed. There's no need to wait. I would advise that you start the process as soon as you possibly can.
Oh, and another thing I wanted to piggyback, which I think is very important in our communities, is if you are a permanent resident and you have convictions, before you travel, go see an attorney, because that's another way that immigration can be aware of your status. Because as we most know, that when you enter the United States, you're fingerprinted. And when you're fingerprinted, your FBI report pops up, and the officers are trained to see if you should be detained, if you should be issued a notice to appear, which will start removal proceedings. So I plead to you, before you travel, if you have convictions and you're a resident or you're a non-immigrant, speak with an attorney, because you may be detained upon entry, you may be placed in removal proceedings, and what's worse is sometimes you may be ineligible for bond, so you can't get out. So that's something I've seen a lot in practice.
Okay.
And I would offer the same advice for visa holders. Like if you're on a student visa here and you get arrested for something, if your case is still pending, do not leave the country, because you will not be allowed back in. The criminal court will issue a warrant for your arrest. And if you ever attempt to come back in, you will be detained at the border.
Yes.
So.
And, you know, you might not get a new visa.
No, your visa will be
because
denied.
now you have an open warrant. Imagine
Yes.
how that looks to a consular officer.
Yeah.
And so you have this unresolved issue. It's difficult. It's resolvable, but it's very difficult and expensive, right?
Yeah.
Thank you very much. So now someone has now been served with NTA and he's now been detained. Can ICE hold that person indefinitely?
No. The answer is generally no.
Okay, what does that mean? You know, when you say generally no, you know, what part of it is no, what part of it is yes?
So generally, I believe it's 180 days, Carla?
Yes. So once you're served with an NTA, you're placed in removal proceedings, correct? And you'll have an opportunity to defend your case. You could even ask bond. You could be asked to be released. If you are not released from detention, you have to present the case while you are in jail, right? These cases may be very lengthy. The court is very backed up. If you're detained for over 180 days, in some jurisdictions, you can request what's called a habeas corpus motion, which is you go to federal court and say your detention has been too long, it's indefinite. Over 180 days is that's the limit. Or in some jurisdictions, you can, in New York, for example, you can go before a judge, an immigration judge, and ask for a hearing because your detention has been over 180 days. But the law is always changing in this area. So it's very important that you keep up to breast with it. Another thing is that not all immigration attorneys are licensed to practice on the federal level. So SRA has a lot of example in federal court. So if I were to have, if I were to have that kind of case, I'd have to refer to SRA or to another attorney to go to federal court because now you're going above the immigration judge to ask to be released. So there are ways to be released if it's been over 180 days.
So are you saying that, you know, someone who has been detained for 180 days, you know, a better practice or a better approach would be for that person to seek for an advice of an attorney?
Correct.
So
yes.
you can't do it on your own.
Yeah. I mean, some people will file what we call the habeas petition on their own. However, it's advisable to find, just like Carla said, an attorney that is familiar with federal practice, because the way the process works is it's like you're requesting something. So you file the petition first. The judge will look at the petition to determine whether or not you have, alleged enough facts to cause the judge to want to look deeper into it. If the judge decides that, okay, something is here, something doesn't seem right, the judge will issue what's called a writ of habeas corpus. That's, in general terms, an invitation to come to court, bring the person that has been detained to court so that the judge can dig deeper and you can explain why you believe you should have been released by this time or you are no longer, you should no longer be held. This happens a lot when people have been ordered deported and the government takes a long time to deport the person, either because the country won't take them back, they can't get their passports or anything like that.
Thank you very much, lady. Thank you very much.
Thank you for having us.
It was a pleasure.
So we hope to see you again.
Thank you.
Yes.
Thank you very much. Thank you for watching Know Your Right on NABNTV. We hope that you find this program very informative. We will be on the air every other week. This will give you an opportunity to send us any questions that you may have. And we'll plan to address those questions during our upcoming show. During the next show, we will continue on the topic of immigration, your rights under immigration law, and we will discuss some of the employment-based green card. Can I petition for myself without a sponsor? Can my church or mosque or organization petition for me? I am a derivative beneficiary of an H visa. Can I get a work authorization? We will discuss these and many more during our next show. We'd like to take this opportunity to appeal to you to advertise your products and be one of our sponsors so that we can continue to disseminate important information about the rights that you have under the United States Constitution and other federal and state laws. Information is power. We would like to equip you with sufficient information and to dispel any misinformation that may be in our community. Finally, please note that this program has not created any attorney-client relationship. If you have a legal matter or pending case, it is best to review all of the facts and circumstances of your particular situation with an attorney in order to determine the best course of action. You may contact any guest or any other attorney for further consultation if you wish. Neither NABNTV nor its host is liable for any consultation you may have with any guest of this show. We are merely providing general information to you. Thank you for watching us.
NABN, New Africa Broadcasting Network.